Good afternoon. We are back. I have a Ryan Wuerch in the waiting room, if that's who we're waiting on.
Judge, he's the one that I have an issue with because he was
Okay,
never
hold on.
listed.
We're not on the record. We're not on the record. I just wanted to say what the situation was first. I wanted to tell everybody what was going on. Okay, now we're going to go on the record. Going on the record at this time, we are back from our lunch break, and Mr. Kazin, I believe your witness is in the waiting room, and your witness that you would call is
Ryan Wuerch.
all right. Now, Ms. Locke, I believe you have an issue with this witness, and you may state it for the court.
Correct. This witness was not listed on any of Mr. Whitaker's requests for disclosures. He was ultimately listed, I think, recently on a pretrial disclosure, but was never listed on persons with knowledge of relevant facts on his requests for disclosures. We believe the only purpose he's here to testify to relates to his supervision of a couple of the visits that he supervised with Mr. Whitaker and his children. So I don't think his testimony is necessary. We're going to stipulate he's going to say that the visits were fine and the kids love their dad. But beyond that, because he wasn't properly disclosed on requests for disclosures, he shouldn't be allowed to testify. Furthermore, on the pretrial disclosure, it was never listed the topic in which he was going to testify about. I assume that's what it's about based on Mr. Kazin's theory of the case, but there was still never any indication of what he was actually going to testify about.
Mr. Kazin.
Sure. If I can show you some of the documents I have on this, Your Honor. Give me just
I need to allow you to share screen. Sorry.
I keep choosing one that's not the one that it shows, apparently.
First, before you do that, is this just a supervisor? And
no, he's somebody that is intimately familiar with both parties as parents. He was chosen by the parties to be the very first supervisor before they had a professional supervisor. He is disclosed on a 194 pretrial disclosure with a list of witnesses from my office. That's what I'm trying to share with the court. More importantly, however, I've got a response to disclosures from the petitioner side that says, and I quote, right at the bottom of it, after all the people are listed, all supervisors utilized by the parties for Rusty, Joseph, Strayford, Whitaker's visitation periods. So they designated Mr. Wuerch. We've designated Mr. Wuerch. The party, I have a May 13th Rule 11 agreement that's filed with the court. I asked the court to take judicial notice of it. It includes the mention of Mr. Wuerch being the supervisor, and I have two supervision reports that are already in evidence by Mr. Wuerch.
I'm going to overrule Ms. Locke's objection to the witness and allow him to testify.
Thank you, Judge.
Is there anything else you want to state for the record, Ms. Locke, before we bring him in?
No, Your Honor.
All right, thank you. I'll bring him in at this time. All right, thank you. You may proceed, Mr. Kazin.
Before I do, Your Honor, I'd like to re-urge my request that you take judicial notice of the May 13th Rule 11 agreement, in which Mr. Wuerch was personally mentioned as a supervisor.
There's no objection.
I don't think I'd ever not said I wouldn't. I don't understand that, but
I just want to make,
if there's something in the file and you're asking the court to take notice of something filed in the records of the court, is that what you're doing?
Yes, ma'am. Yes, ma'am.
Then the court will take judicial notice of that file. Yes.
I just wanted to do that in light of the remarks that were made before we admitted him.
Understood.
Okay. Mr. Wuerch, I'm David Kazin. I'm Rusty Whitaker's legal counsel. And is it true that you know both Rusty and Lacey Whitaker?
It is.
Okay. Do you how do you know them? Do you live close by? Get us familiar with how well you know these folks.
Oh, absolutely. Well, both I believe I met Rusty first. We were living at the time at Spanish Oaks Golf Club, which is where Rusty and Lacey and the kids lived as well. And I believe we met in 2018 or 2019. And it was really from the very beginning, began forging a really deep relationship with Rusty, Lacey, and the kids. And it was, I think, probably shortly thereafter, became one of those deep, close relationships where we did things together, come over to the house. They live not too far away. Kids, as well as them, began calling me Uncle Ryan. And just since that time was a very close relationship.
Do you have children of your own?
I do. Yes. 4 sons now, 31, 29, 20, and now 18.
Okay. So they're quite a bit older than the Whitaker kids.
Absolutely.
Okay. And the parties asked you to play a role in this case when Mr. Whitaker became incarcerated. Do you recall?
Yes.
Okay.
Well,
what-
and I think it was not them asking as much as it was just assumed. I was very close to the both of them. And really, at the time of both Rusty and Lacey separating, began, in earnest, very close relationship with both Rusty and Lacey, one as individuals and as parents of the kids.
Okay. Did you So if you could take us back to the time when you first found out that Mr. Whitaker had been arrested. How did you find out?
I was actually in San Francisco for a board meeting, and received a phone call. Can't remember the day. I think it was in June of last year, if I recall. But I received a phone call, or first a text from Lacey saying that Rusty had been arrested. I believe the text said, but we got on the call shortly thereafter, and within a few minutes, and she was on a business trip herself, I believe in Illinois or Ohio, and she gave me what had transpired that morning with the FBI and Charlotte police coming to the house, and her receiving a phone call from Vanya, I believe it was Vanya, who was their nanny for the kids.
I see. Now, during this time, since that moment, have you had contact with Mr. Whitaker, although he's been incarcerated?
I have actually. I had not talked to him since the summertime until just this past few days, where I talked to him. He had reached out, and I spoke to him just very briefly, but really from the very beginning, I felt like I was playing a role between the two of them, and trying to keep relationship separate, friendships with both parties, as well as being close to the kids and related to Rusty. I would talk to him periodically. I went and saw him just one time while he was incarcerated there in Austin, and we'd talk periodically. I'd receive a text from him periodically, and then it definitely began diminishing just because of where he was when he got transferred to North Carolina.
Okay. When did it start to trail off?
Most likely it was probably in, I want to say, the May time period. I could be wrong, but I believe it was in the May time period of this year, April, May.
Okay. And so from May or April to just about a week or so ago, you really hadn't been in touch with Mr. Whitaker. Am I understanding that correct?
Correct. One of the more substantive times where I've seen him and had conversations with him is when he was at my home and I was doing supervision of he and Desi,
I see.
their daughter.
Okay. So let's talk about that for just a second. I want to show you, you actually performed that supervision and then drew up a report, did you not?
Yes, I did.
I'm showing you on the screen what's been previously marked as Respondents Exhibit number 68. And I'll ask you this, it appears to be dated May 15th. Is that when the supervised visit happened?
I believe so.
Okay. In your own words, would you tell the court kind of what you observed in that particular interaction between Mr. Whitaker and his daughter?
Well, as I wrote here, looks like this is what that I put together. Rusty arrived to the home. I believe Lacey. I was running late, and so Rusty wanted to get things set up, and I had made my office at my home available for him to spend time with both Desi and himself. And so he wanted to get there before her. So he had said he had bought her some presents and bought some things for her, and had things he wanted to lay out for coloring. She loves to color and draw, and so we wanted to have it set up. So I told him to actually, I had my son, who's now 18, he let Rusty in and told Rusty where we had laid out things for him to be able to meet with Desi. And shortly thereafter, after arriving home, Lacey brought Desi to the house, and I brought Desi in. And the moment she saw her father, I mean, it was like she had just showed up at Disney World. She was so excited, and screaming and running into his arms. And then over the course of, I believe, 2 hours, they spent time in the office, and I kept myself to where I could hear a conversation, and it was
I'm going to object as to hearsay.
Your Honor, this gentleman was court approved to be the supervisor, and
I'm going to sustain hearsay.
Okay.
So you can't say what the kid said, but you can
Okay.
talk about what you observed that doesn't involve
I
their
observed.
actual comments.
Absolutely. So what I observed is just a father and daughter having a great time together, and in the other room, and because I saw it, drawing, playing with some of the things that he bought her, and he had also asked to have swimsuit packed, which she came with, and they went out swimming. I stayed outside while they were swimming and playing in the pool, and just having a great time together as a father and daughter.
All right. There was one other visit that you supervised, was there not, sir?
I don't believe so. I can't remember if there was.
Let me just show you something that's already been admitted into the evidence here. This is the next day, I believe. May 16. Oh, I'm sorry. This is not
No,
you.
that's not me. No, I know that was another one that was going to happen the next day, I believe.
I see.
All
I see.
the
That one's not you. So let's talk about your observation of Mr. Whitaker apart from and going back in time. Going back in time from before the time of the arrest and the supervision and all that we just went through. What kind of father is Rusty Whitaker?
Well, from just the times that I obviously I observed since the beginning of the relationship, this was a man who loved his family. That was always something that was that was seen, and he wanted to be the best dad. I mean, these are the conversations that, we had, whether it was, him talking about the kids and the most important thing in the world to them, whether birthdays, baseball, golf with Weston, um, taking the kids to Blue Jack, even after Lacey and he had separated, Disney cruise, wanting to make sure that the kids had a great relationship with him, as well as were able to enjoy being kids. Shared with me some of the difficult challenges he had, growing up as a boy, as a son. And, one of the things he always asserted is he wanted to provide for his family, unlike how he was provided for, and wanted to be the best parent possible. So, what I observed is, as a man who truly wanted the best for his kids and wanted to have a great relationship with his children.
So during the time that he was incarcerated, the first time around when he was not out so that he could have these supervision times, he's been incarcerated one period of time and then now another, first under state care and now under federal care. Are you aware of generally that outline, sir?
I am now. I wasn't aware. I had no communication with either one of them really since the summertime, and so I was unaware that he was back in custody or back in incarceration.
So when Mr. Whitaker was first incarcerated for some period of about 8 months, beginning in early June of 2023, were there how much contact did you have with, or how much interaction, let's put it, did you have with Lacey Whitaker?
Quite extensive.
Okay.
Outside of this, and since the summer, but prior to that, I would say almost daily.
Okay. And did you get to observe the kids with Lacey Whitaker?
I did.
Okay. Did I understand you correctly that they refer to you as Uncle Ryan?
They have for a long time, yes.
Going all the way back to before Mr. Whitaker's incarceration, is that fair to say?
Yes.
Okay. You're aware of what the allegations are against Mr. Whitaker?
I'm not sure what you're referring to.
Well, in general, are you aware why he's incarcerated at the moment?
I have the outline of it, of what took place, but I don't know. I don't have all the details. In fact, he's made sure when I've talked to him, he would never really discuss anything related to details, and outside of what I've learned from the time with Lacey and the things that I've heard that she's learned or things that I've read, I do know what's been alleged.
Right. And do you the man you've known as Rusty Whitaker all this time, and having that picture in your mind, all together with whatever it is you understand the allegations to be, and knowing these children who call you Uncle Ryan, do you think that he's in any way a harm to his children?
No.
So you're not here under subpoena. You're here voluntarily. Is that correct?
Correct.
Why did you feel it was important to be here voluntarily?
Again, thinking about the children, and I know how important it is for kids to have parents that love them in their life. The world needs more of that today for children, and I know how both these parents love their children, and I love these kids.
Is there any doubt in I'm sorry, I cut you off.
No, I said I love those kids and I want the best for them.
Is there any doubt in your mind, based on the children you come to know and who come to know you as Uncle Ryan, that these particular kids need both their parents?
I believe so. I know, I know in preparing for this morning, this brought back way too many memories. When I was with Weston, I took him to a Texas Ranger baseball game up in Arlington earlier this year, and we spent day together, and he spent the night at my house with our family, and just the conversation going up there and knowing
I'm
how
going to
much.
object to hearsay because we're going to talk about what the child said.
Mr. Wuerch, just want to be careful because the court's given us instructions.
Sorry, I was sneezing, but yes, that's sustained.
Okay.
You can't talk about what the children told you.
That's fine. No, so I'll just, I know how much these kids are loved by two people, and I know how these kids love their parents.
All right. Is there anything else that's important that you think the court needs to know based on your experience with this family about anything that's really important to these children and about the decision that the court's got to make about how to arrange further contact between parent and child?
Yeah, I can't speak to what's going on with Rusty and where he is right now and that whole matter. What I do know is life's a long time, and I know how important it is for kids to have parents that love them in their life, and I know how much I do know how much Rusty loves these kids, and I know how much these kids love their dad. And I was in a very not. I was in a similar situation, when my boys were 5 and 3 years old, and my former wife, who was well-educated speech language pathologist, left me and the boys and began doing things that really compromised her. And through all of it, through my divorce and custody hearing, I always tried to remember that the boys needed to be kept first, and not my hurt or my ego or my pride. That I knew that time would be a great thing, would always work things out, and it was important for the boys to have a relationship with their mother. So I ensured that there was always the right visitation. The boys always knew that I wanted them to know their mother, and I'm glad I did, because now as I look back, 3 years later, their mother was in a different place mentally, and the whole process, now look at my sons who are 31 and 29, and they still know to this day that I wanted the very best for them. And I always encouraged them to have a relationship. And that was, they were going to be 18 one day and you're going to get to have that, but they would always know that up until the time they were 18, I was someone who was always going to make sure that they knew their mother, who actually loved them.
Yeah. Do you see this as kind of analogous?
I do. I think that's, I guess because it's tough. Like divorce is tough. Custody hearings is tough. Protection of children is tough. And, I have a real-time relationship, with those kids, and have had the opportunity to witness to individuals who truly, truly love their children. Irrespective of where they are in their own lives, they love their kids.
Thank you very much, Mr. Wuerch. I pass witness.
Mr. Wuerch, was your ex-wife accused of seeing a 15-year-old?
She was not.
Okay. What were her charges?
She unfortunately had activity with drugs. She ended up having to have some time getting personal help. She unfortunately just made some tough decisions.
So this is really not an analogous situation, is it? Because Mr. Whitaker is charged with predatory behavior towards a child, correct?
Yeah, I'm sorry, but I don't know all the charges.
Sure. Well, I'm gonna show you what's already been introduced.
I know, but I know that's what I've heard. So you don't have to, I know that's what I've heard.
Okay. Well, I'm going to show you what's already been introduced into evidence as P14, which is the actual incident report from the allegation that's given rise to this, to his criminal charges. This child, the allegation was from the police report. This is public information, was forcible that resulted in serious injury to a 15-year-old girl. That's entirely different than a drug addiction issue, isn't it?
I would say yes.
Okay. And there's evidence already in that matches Mr. Whitaker's credit card statements with hotel reservations in North Carolina at the time of this incident. So we can make whatever inferences from that we want, but that is not the same situation relating to the children, right? That's what happened with your boys.
Yeah, I was, specifically saying that, I went through divorce, went through custody, was not in any way saying both people are like. The analogous part was I was a father of two little boys who had custody of the children and knew that it was important for the kids to be able to have a relationship with their mother.
Were they visiting their mother in prison?
No, they were not.
Okay. And in fact, tell me this, you've testified that Mr. Whitaker is a good dad and really puts his kids first, right?
I did.
Okay. Are you aware that he missed Desi's recital to go on this trip as a 15-year-old?
I'm not.
Okay. Does that change your perspective on what kind of good father he is?
Yeah, making choices. I can't speak to that. What I can say is my time with him and him knowing the children and loving the kids, I know was real.
Well, I'm not saying it's not real, but does a good father engage in that behavior and put their child to the wayside to go engage in criminal activity?
Yeah, that part, obviously that is a wrong decision.
Okay. I pass witness.
Anything else, Mr. Kazin?
No, Your Honor.
All right, thank you. Mr. Wuerch, you are excused as a witness and you're free to go.
Thank you very much.
I see no one else in the waiting room right now. Are we ready to go back to Mr. Whitaker, Mr. Kazin?
Yes.
Okay. Then, Mr. Whitaker, you are still under oath, and we can pick back up where we left off. I know that Ms. Locke has someone coming around too, but I think we'll just continue going forward with Mr. Whitaker in the interim.
That's fine, Your Honor. Mr. Whitaker, can you hear me?
Yes, sir.
Okay. I'm about to ask you a bunch of questions about your kids as a fairly strong shift away from property matters. But before I do, I want to make sure that I've given you an opportunity to address everything that you think is important about the difference between our proposal and Lacey Whitaker's proposal. Is there anything that I missed that you would like to address, and on which spreadsheet should I bring it up?
Yeah, I would say there's probably three things
Okay.
on, I mean, you can go to our spreadsheet, or actually you can go to their spreadsheet.
Okay. All right.
You can go down to page, I think 2 or 3.
What's the topic?
Well, first of all, the first topic is on you, line number 85.
All right.
And actually, this isn't a discrepancy. This is a privately held business. And I just want to point out that both spreadsheets, I believe, agree that it should be split 50-50
Okay.
because we don't know the current value of it.
Okay.
Next page. You just I guess it's one more page, whatever page it is about the Constitution.
Okay. That was ahead. We skipped over it, but here it is.
Okay. Line number 98.
Okay, this is about the Pokemon cards, correct?
Yeah.
These cards, are they still in existence?
Yes, sir.
Well, there's a request for a reconstitution for the money spent on them. Where are the actual cards that were purchased?
There's a section of cards that are in Weston's possession, from what I understand, and a portion of unopened cards that are in Lacey's possession.
Are they worth what's on here as a value?
No, sir. They're worth a good bit more.
Well, is there a place for those on this spreadsheet?
I would argue, Weston's cards are Weston's cards. He has about $15,000 to $20,000 worth of cards in his binder. From when we received the pictures from Lacey, I was able to, appraise some of them, and they came out to well over this figure. And then there's somewhere around $5,000 of unopened boxes and packs that are still in her possession, that she had texted me 3 times, and my brother multiple times, asking us to pick them up from her. We attempted to, and she never turned them over to our possession. And then now, with the claims that I've used them for some ill purpose, which I haven't, and I can testify to the nth degree on that. They want us to reconstitute them.
Well, so let's bring it out in the open. What is the claim that you've heard your wife's counsel make about what's going on with Pokemon cards?
Well, what they said yesterday is that I purchased Pokemon cards on Discord, and that I was using them to somehow meet children, and I can adamantly deny that I've never purchased Pokemon cards on Discord, first of all, and the only children I've discussed or played Pokemon with are my children and their friends.
So a reconstitution claim, as it's cast here on this spreadsheet, is supposed to be about some breach of fiduciary duty that you did in an expenditure of $1 or more. Is there anything about your purchase of Pokemon cards, either to trade or to give to your son, that is a breach of your fiduciary duty to your wife?
No, sir.
You're stating it's a completely spurious allegation.
Absolutely.
Okay, thank you for making that clear. Is there anything else about this category that you want to discuss?
If you go to the next section, there's a cell phone reimbursement request. It was actually with AT&T, not T-Mobile. This was a business phone, and if we knew this was a waste claim, we just learned about this yesterday, we would be able to provide the AT&T business statement, but that phone on the statement was linked to my assistant's phone, which was conveyed in the sale of my business.
You raise a good point about when we learned about some of these claims. So I want to ask you, I'm going to go all the way up here to, you see where this community funds held in trust is listed, and this $100,000 going, as they say, they want it to be prepaid in child support. You see that, sir?
Yes, sir.
When was the first time you saw this on a court filed pretrial form?
Yesterday.
Any other major points about this particular pretrial form that you just
Yeah,
saw?
there's one more big discrepancy under club memberships and rewards under line 70 and 71. I would just point out they're listing my small amount of Southwest Airlines and American Airlines rewards. We had requested Lacey's multiple times. We never received it. She has probably close to 1 million Southwest airline miles. What I would tell the court is I don't care about the airline miles. She can have them. I just don't want to go through the challenging process of trying to give her my $6,000, 6,000 miles as they're requesting here on this statement. We're not requesting her to give me any portion of the million miles that we have and accrued together on Southwest. And so that would just be more hassle than it's worth.
All right.
They're also, oh, sorry.
Well, and we went through yesterday how, in terms of everything that's over in your column, some of those things are not in existence today, meaning even though there's dollars in this column, you wouldn't actually be getting value walking away from this estate. And so you saw on our spreadsheet, I expect to have a receivable still of some $36,000. We've had some recent expenses with depositions and depots on written questions and rather significant expenses, mediation as well, here in the last 2 weeks. Have we not, sir?
Yes, sir.
And if you have this receivable, not to be selfish or anything, but would you have much ability to pay my bill under their spreadsheet?
No, sir.
All right. One last time, I just want to make absolutely sure. Is there anything else about Lacey Whitaker's proposed division of property that needs to be discussed?
Actually, I believe two more things just came to mind, Mr. Case.
You want me to back on yours?
No, right here's fine. The first one is they want, I guess, a reconstitution for the au pair expenses. Somewhere in the neighborhood of $11,000, I believe, is what they were asking. But I don't necessarily see it here, but I'll just speak to it real quick if that's okay.
Yeah, sure. If to the extent that she is asking for that, if that's part of her request, what would your response be?
I would say that money came out of community property. It's already been spent on the au pair. You know, she and the kids need support, and I, since it came out of community property, I'm essentially paying 50% of it already, and so I believe that, I don't believe I should be reimbursed for the 50% that I'm not going to be able to benefit from, but I also don't think that there needs to be any kind of reconstitution there. It's already been spent, and let it go.
Now, there's what looks like a reconstitution number, but it's not under the reconstitution banner, where these fees for the protective order were incurred. Do we have any documentation that shows that figure on her attorney's fees?
No, sir, but I can talk to it if you'd like.
Well, what else do you disagree with about this number?
Well, I had similar attorney's fees leading up to that hearing, and ultimately I can discuss on how the protective order came about if it's relevant to the court. But
well, let me ask you first: does the protective order that's in place have any finding of family violence?
No, sir.
That was specifically excluded from the protective order now in place.
That's correct.
At the time you agreed to it.
Judge, I'm going to object as to relevance on this particular line of discussion because it was an agreed protective order. He agreed to the terms of it.
Well, I think I have to allow it because I think you're seeking a fault ground divorce on domestic violence. And I think I have to allow it on that basis. So,
Okay.
overruled. I think it's defensive as to your claims, I think.
Okay.
All right.
Thank you, Judge.
So overruled.
So Mr. Whitaker, what were you saying before you were interrupted, sir?
Well, we arrived at court, and unfortunately there was not a judge available to hear our case. My son's birthday was the next day, and I was advised by my counsel that I would not be able to be present to see my son on his birthday or see my children that week unless we agreed on this protective order. But we also agreed that the protective order protected me because Lacey got really aggressive when I bonded out. And my criminal attorney was extremely concerned about the communications from Lacey. And we believed that by not having an open forum that was unrecorded between Lacey and I would actually be in the best interest of me and the criminal case that I'm fighting.
Okay, so this was something that both sides had their need for.
I believe so, yes, sir.
All right, before we move off of this, is there anything else about this proposed disposition that we need to address for the court's consideration?
At the bottom, there's the children's property. I think we all agree, from what I can tell from their spreadsheet, to split, well, maybe it changed, but it looked previously, to split the 529 accounts and the UTMA accounts for the management, so we can both, continue on our path to save for the children's education. We have much different investment, styles, and, I would like the opportunity to continue to manage half of their 529s, UTMAs, and be able to contribute to them between now and to go to college.
Yes, sir. The thing that changed between their first proposed disposition of issues that was filed on due date 2 weeks before trial versus the one that was filed yesterday morning is lines 172, 176, and then, well, I see 2 removed. Oh, and I think this is mislabeled, but it says Pokemon cards. I don't know why it says that. 169. Nonetheless, the Schwab accounts that were previously down here below the line are now above the line and are divided in half between the two of you. Do you agree with that?
Yeah, I don't think there's any dispute on either side. I think we all agree that those should be split 50-50.
All right, but as it regards, and I'm sorry, Your Honor, for bouncing around here, but as it regards the 529s and the UTMAs, Ms. Whitaker still has those completely in her side. It's only the Schwab accounts that I believe that she's agreed to divide with you. What is your feeling about operation of the 529s and the UTMAs?
I think it would be a pretty easy split to split those accounts between us so that she'd be able to manage half of those and contribute to them if she'd like to, and I'd be able to manage the other half and contribute to them and if I'd like to. As custodians of those accounts, we don't have any access to them. We can only use them for the benefit of the children, and I feel very comfortable with her being able to manage half of them.
Okay, so I'm about to move on to the kid stuff, and before I do, is there anything else that we need to address here?
They don't have they have the Cadillac Escalade as a zero balance. We had been approved by the court to sell it. It's about $4,000 or $5,000 underwater. I'm not sure of the status of it, but that's just one minor omission. Other than that, I think we're good here unless Your Honor has any questions.
All right.
Well, I have lots of questions, but I'm going to have the lawyers come back to me on some of these issues because it remains, again, represented to me as everything's basically agreed as to the issues regarding the estate. And it hasn't really played out that way, I don't think. I think there's significant issues with regard to the estate. So, and I've gotten bigger pictures on that. But for now, it's Ms. Locke's turn on that. If your lawyer is done with you on this point.
Oh, I thought Mr. Case had more questions about the kid
Oh,
issues.
he does?
Yeah, that's what I heard him say.
Oh, okay.
Yes,
Then keep going,
haven't
Mr.
even-
Mason.
haven't begun to ask kid questions, Your Honor.
Okay. Then we're moving from financial to kid questions.
That's correct, Your Honor.
Then why don't we take our break? I think that's probably, rather than getting started on kid questions, I think it makes sense to take a 10-minute break while Ms. Locke's witness gets here, because I believe she's coming at 2.
That is correct.
Then let's do that. And we'll wait for her to arrive. I'll see everybody back at 2:02, and hopefully she'll be here and we can call her at that time.
Thank you, Judge.
Thanks. All right, everybody is here. Thank you. Sorry for my delay. We will go back on the record, and we're going out of order. And Ms. Locke, you may call your next witness.
Sorry, Judge, I was having technical difficulties. I call Sonia Desai.
All right, I'll bring her into the Zoom.
I do.
And then you'll be asked a series of questions, first from Ms. Locke, who represents Lacey Whitaker, and then likely from Mr. Kazin, who represents Rusty Whitaker. Ms. Locke, you may proceed.
Thank you. And Judge, I want to make sure the record was clear. My understanding from Mr. Kazin that at least on the 2 traces that Ms. Desai did on Ms. Whitaker's account, there was not a dispute with regards to those traces. Is that right, Mr. Kazin?
That is correct.
Okay. So at this point, I would move to introduce, let me pull up the exhibit. I would move to introduce P40. I'll share my screen.
P40 is admitted.
Thank you. And this, Ms. Desai, is the report that you created tracing the separate property interests in the GE Healthcare Retirement Savings Plan. Is that right?
Yes, that's correct.
All right. And you also did the tracing on the Waste Management Employee Stock Purchase Plan. Is that right?
Yes.
I'm
Okay,
sorry.
and-
I need a little help. I'm just going to have to stop y'all. Is this, which tracing is this? Is this, that's what you need to help me with, right? You just said
Yeah.
there was an agreement. Is this the stuff that's agreed to, or is this the stuff that's not agreed to?
This is the agreed to amounts for my
All right.
client's
Thank you.
accounts.
And this is, and Mr. Kazin agrees.
Correct.
Okay. Thank you.
So the court is clear, because Mr. Nikase and I talked about this on break, just to explain to the court. Mr. Kase and I have agreed, and I think we can probably do a joint spreadsheet at the conclusion of this. 'Cause I think the court will, well, I don't know what the court's going to do. That being said, there's a bunch of values we agree to. The disputes, which is what the court wanted us to point out, relate to separate property characterizations, and then what percentage of separate property or not. So the numbers with regards to the actual account balances are agreed to. The fight comes down to what percentage, if any, is separate property, and et cetera. So I think it's down to like 5 or 6 accounts, and the tracing on those of whether they're separate property or not. I think those are the issues in dispute, other than what we have talked about already, which is the wasting or the reconstitution claims for the attorney's fees, the bond amount. I think those things are the
But what
amount.
you're showing me right now are Ms. Whitaker's accounts that are confirmed as her separate property. What are you showing me right now?
I am showing you the total account balances that we have placed on the spreadsheet, and the percentage of which that result from separate property and community property. And the spreadsheet that the court has before it already contains the split based on this document with those numbers. And so if you want me to pull up the spreadsheet, Judge, I can show.
I didn't understand. So there is a community, these are community property accounts, but a portion of each of these community property accounts have some separate property of Ms. Whitaker. And everybody agrees that this is her separate property.
Correct.
All right, I got it.
Okay. And Ms. Desai and Mr. Kazin, are you going to stipulate that she's an expert, or do I need to go through her CV?
I will certainly stipulate that she's an expert.
Thank you. Appreciate that. What was the methodology that you used when you came up with the tracing for Ms. Whitaker's accounts?
I use the community out first methodology to trace her account.
And how do you properly trace these types of accounts where there's stocks and investments and contributions? What's the proper way to trace them so that you can determine what the true community property is versus a separate property?
In my opinion, the proper way to trace these accounts would be at the investment line item level. So it would be looking at the transactions, each purchase and each sale of the investments that are held within the account. And then for any sales of investments that are held, again, there would be a community out first principle applied. So if some units of an investment are sold, you would assume that they are sold out of the community property balance of that particular investment.
Why is that important to do the line item tracing on those particular investments and transactions?
Well, first, community out first is a widely and generally accepted tracing methodology. And, typically in my experience is the preferred methodology that is used where it is possible to do so, where the transaction information is available. Okay. Where it becomes very important to do it that way is when the investment holdings are changing during the period in question. And so where you have an investment portfolio and you are buying and selling investments, reinvesting amounts into new securities, it becomes more important to look at the specific investments by line item, because the community portion may start in one investment and end up in another investment. And as we all know, different investments perform at different rates of return. So that's why we look at it at an investment level basis.
All right, so I'm going to show you what Mr. Whitaker prepared to trace his separate property, and let's talk about that. You've actually had a chance to review this, haven't you?
Yes, I have.
Can you tell the court what your concerns are with the tracing that Mr. Whitaker did with regards to his Exhibit 50?
So from based on my review, what I can tell is that there is a period of about 3.5 years at the beginning of the marriage, roughly 2016 through July of 2019, where there are no statements. There are no statements available. And so, number one, I haven't actually seen a statement confirming Mr. Whitaker's premarital investment balance, what he owned, bringing it, what he brought into the marriage. Then
what is one of the, so that's one of the issues. What are some of the other issues?
Yes. Some of the other issues are that for this missing time period, this 3.5 year time period, the methodology that Mr. Whitaker appears to be using is that he assumes a hypothetical investment portfolio. He assumes that all of his payroll contributions that were made into his 401k account during this time period would have been invested into the S&P 500 index. And he uses the S&P 500 performance during the time period to then estimate all of that community property contributions that were contributed to the 401k, that they would have grown or declined at the rate of the S&P 500. However, in reviewing his investment statements subsequent to July of 2019, it does not appear that Mr. Whitaker invested in the S&P 500. He had a what I would consider to be a diversified investment portfolio. He invested in, stocks, in fixed income bonds, in different mutual funds and exchange traded funds. And not only that, throughout the period that I was able to review statements for, he was actively rebalancing his investment portfolio. So it's not as though.
And forgive me, because I don't know. What does rebalancing mean?
Yes. So what that means is that if you invest in Tesla, you're not just leaving all of your money invested in Tesla throughout the duration of the marriage. You are taking, reevaluating periodically, taking some out of Tesla and putting it into Apple. And then maybe you take some out of Apple and put it into a bond. And so every periodically, I'm not sure at what frequency, it appeared that Mr. Whitaker was doing this in his investment portfolio. He would liquidate certain investments and then reinvest them into alternate investments. And this was happening throughout the marriage that from what I could see.
Okay. And why is that an important part of your analysis of his tracing report?
So you might recall, as I testified earlier, when you have an investment portfolio that is changing as frequently as it appears to be changing here, you don't know where the community property is. You can't assume that the community property is equally distributed amongst all of the different investments that are within this account, which, from what I can tell, seems to be the approach that Mr. Whitaker is taking. He's using what I would call the pro rata approach, which is to assume that the total growth in the portfolio or the total decline in the portfolio is shared by the community and the separate property balances in the ratios that he determined at the very beginning, which again was an estimated amount. And so rather than just assume that all of the separate and community property investments would perform at the same level, for an investment portfolio like this one, it's important to see where is the community property actually invested and what is its performance, because this is a portfolio that is continually changing.
And could the continual changing of the portfolio change the percentage? Let me rephrase that. So if we could identify what the community property was, is it possible that the community property outperformed the separate property, that the percentage of community property would be a larger portion otherwise?
It is
That
possible.
question makes sense.
Yes,
Okay.
there's no way of knowing without doing a line item tracing.
Okay. And in anything that you reviewed from Mr. Whitaker, was there a line item tracing?
Not from what I could see, no.
Okay. And what is the problem, if any, with regards to the pro rata approach for determining by clear and convincing evidence what is his separate property?
Well, again, it's for the judge to decide, but from my experience and from the numerous tracings that I've done, the pro rata method of tracing does not reach the clearing and convincing standard in an investment portfolio that is, again, changing as much as it is here, where investments are being sold and reinvested.
I'm going to share with you Exhibit 81. And Judge, I'm going to move to introduce P81, which is Mr. Whitaker's IRA before it rolled over into the current one that's on the balance sheet. But this is statements that we received pursuant to the subpoena.
Your Honor, I have no objection to it, but while I'm speaking, can I get an understanding of time, Your Honor? Because it seems to me...
She's got about 15 more minutes.
Thank you, Judge. And I'm sorry, was this one admitted?
What number is it again?
It's 81, Your Honor.
81's admitted.
Thank you. And this was just one of his statements from 2022 from one of the accounts. And this is what summarizes his trading. And you reviewed statements like this of Mr. Whitaker's. Is that fair to say?
Yes.
Okay. And it shows how he has his assets divided. Is that correct?
Yes.
All right. And in your review of all of the statements that you did look at, does this seem to be consistent or not consistent with his usual split of how he has funds allocated?
It actually varies. There were some periods of time when it appeared that he was almost fully invested into the exchange traded funds and mutual funds. And then other periods of time, he started to invest into the stocks and fixed income.
How often in your review of his records did you see where he was invested solely in the S&P 500 index?
I was not able to identify any investment statement in which he was fully invested in the S&P 500.
And then when you do tracing and rollovers, is it important to trace all of the funds?
Yes.
Okay, so let's show you. I'm going to move to introduce in just a second, Judge P79 and P80. Tell me this, Ms. Desai, on the information that you've seen and reviewed with regards to Mr. Whitaker's tracing, would you have been able to perform a tracing on these accounts?
I would not. And the reason is that the there was a significant period of time, again, in my opinion, a significant period of time where there were no statements available for how for what happened in these accounts. We don't know if money was withdrawn. We don't know if how money was invested. We don't know how much interest and dividend income was earned. And so with that large of a time period where we don't have statements, where it's possible you can make reasonable assumptions. For this length of time, I wouldn't feel comfortable making assumptions. And if I did, I would say the assumption being made here is not reasonable because it appears to be inconsistent with Mr. Whitaker's investment behavior. He's assuming S&P 500 when that is not historically how he has invested his money.
All right, so I'm going to share my screen one more time. I'm going to show what's been marked as P79. And this is the most recent statement that we have that we received pursuant to subpoena for the account summary ending in, looks like it's 2024 as of October 2024. I'd move to introduce P79.
No objection.
79's admitted, 10 minutes.
Thank you, Judge. I'm going to share my screen and show you what has been marked as, I need to stop this share, as P81. P81, I will move to introduce a judge, and it is the additional Genesis Wealth Management IRA from Mr. Is that the right one? Yes, P81 that shows the specific values.
Excuse me, Judge. I have that P81 was already admitted.
Oh, then maybe P80. I'm sorry.
Okay. Thank you.
Sorry.
Well, you were showing me 81.
Yeah,
but it's 80.
Correct. Yeah, Judge, I think I messed up. I think I showed you P80, not 81, and 80 should have been the one admitted, not 81. So can we swap them out on the record?
You're withdrawing 81. 81 is hereby withdrawn.
Correct.
We have admitted 79, and now you are offering 80.
Correct. The correct 80.
Well, I'm telling you what you just showed was 81. And so I don't know what's correct or not correct. Mr. Kazin and I are going to go by what's in the box. What do you believe 80 is? 80
is the LPL ending in 3498, 622 to 2024 present statements.
And can you show that to us?
I sure can, Your Honor. And that is P80.
Any objections, Mr. Kazin?
I'm fairly sure, based on what I'm seeing, that it's the same P80 that I have.
It is the same P80.
It looks like 80 to me as well. So I'm going to admit P80.
So I'm clear, 79, 80, and 81 have been admitted. Is that correct?
You withdrew 81, but you want to readmit 81 now.
I want to readmit the correct 81, Your Honor.
Well, I don't know if they were ever correct or incorrect because what you show on screen doesn't really matter. What's in the box has mattered the whole time. But do you have any objections to 81, Mr. Kazin?
I'm thoroughly confused about what 81 is supposed to be because of what got shown versus what got stated about it.
Well, I'm showing 81 right now. Oh, I can't. 81 is the LPL statements accounts ending in 6172 from 2022 to 2024.
What page is that? That's 90.
Well, that's the bottom. That's the bottom of the document, which shows the transfer out in this year, and then the very first page is the first part of the records, which is January 1st of 2022.
So all I'd say is that it looks exactly like what we started with, which means I don't know what the confusion was or.
Me neither. I don't really think there was much confusion. I think we made it harder than it needed to be. 79, 80, and 81 are admitted. I believe they are correctly marked and they are correctly in the box as marked. Go ahead.
I actually passed the witness. I just need to get those three statements in, Judge.
All right. You're up, Mr. Kazin.
All right. Ms. Desai, The community out first principle. You familiarize yourself in connection with your work as an expert with case law bearing on how to account for what comes out of what account. Is that fair?
If you're referring to the application of the community out first tracing methodology, then yes.
Community out first came from case law, did it not?
Yes.
Okay. In that regard, it's important to know what the case law says about tracing community from separate and separate from community. Would you agree?
I agree.
Have you ever been an expert in a situation where the plan administrator changed and certain statements for a period of time were simply unavailable?
I've been engaged on several cases where there have been statements that have been unavailable. That would impact my ability to trace the balances in those accounts. But yes, I have experienced that.
Okay, and so when a plan administrator changes and the statements for a period of time are unavailable, are you saying that there's no way to make reasonable assumptions about what the separate from community is?
Well, I'm not saying that it's always difficult to make reasonable assumptions. I think that there could be instances where you could make a reasonable assumption. However, I do not believe that in this instance, a reasonable assumption was made.
So you testified a moment ago that you didn't think the pro rata method led to a clear and convincing outcome. Do I have that correct, ma'am?
That was my testimony, yes.
And, since we went through that, it's good in your role to be familiar with case law. Are you familiar with a case that says that?
I am aware, I'm not sure what case law you're specifically referring to. However, I am aware that the pro rata tracing methodology is available as a tracing methodology. I'm not testifying that community out first is the only acceptable tracing methodology.
In fact, you're perfectly aware that there are several pro rata method cases that are perfectly acceptable as clear and convincing. Agreed?
I do agree that pro rata tracing methods have been accepted by the courts, yes.
All right. Are you familiar with Horlock reimbursements?
I'm generally familiar with them, yes.
Generally, in the Horlock case, a gentleman was unable to trace his separate property stake, some $900,000 and change, used it to grow a $4 million community estate, and was nonetheless reimbursed his $900,000 separate property stake without tracing at all. Generally, that's the outline of the Horlock case. Would you agree?
Well, I wouldn't agree that case is applicable in what is happening here in Mr. Whitaker's tracing. The separate property balance at the date of marriage is undetermined, in my opinion. There has not been any evidence to show what separate property was brought into the marriage. It's merely an estimated amount that is based on an unreasonable assumption of how the portfolio was invested. There has been no establishment of the separate property as of date of marriage.
So mathematically, it's possible to know what the balance was on date of marriage if you have all the contributions and you have a general understanding of the nature in which the assets grew or declined in the market. Would you agree with that?
I disagree with that. I mean, you would need to have an understanding of how the investments in the account grew or declined during the missing period in question, not just the market in general, just specifically the investments within that account.
Well, I know some investments are different than others, but you're saying to the court that there's no matter what separate property stake somebody has in an account, if you're missing accounts right at the outset, then what? They lose their separate stake entirely? Is that your testimony?
That's a decision for the judge to make. My testimony is that from the evidence I've reviewed and the tracing that Mr. Whitaker has prepared, it is not my opinion that the separate property that was brought into the marriage has been established with clearing and convincing evidence, and that the method that he is using to back into that estimated number is unreasonable, in my opinion, based on his use of the S&P 500.
Well, let me just take a shot at this, because if somebody had somewhere in the neighborhood of $300,000 in separate property invested in a 401k account, and then they got married and the statements were missing for the first 3.5 years, but the dollars contributed during those 3.5 years were known without any question whatsoever, and you knew, generally speaking, what kinds of equities the asset was invested in, you'd be able to come within a pretty good approximation of what the beginning balance is. Would you agree with that?
If you knew how that money was invested and what securities they were invested in, then yes, I would agree that you would be able to reasonably estimate the date of marriage balance.
And once again, my question is not precisely no. It is reasonably no within a decent range. So even if we're off by just, a few percentage points one way or the other, it would be unreasonable to take the separate stake and render it to zero. Would you agree with that?
Again, this is your line of questioning is predicated on there being a reasonable assumption applied. As I've said already, I do not believe the assumption being applied here is a reasonable assumption. If a reasonable assumption were applied, I would agree that you could reasonably determine the date of marriage balance.
All right. Thank you very much. I appreciate your time, and I pass the witness.
I have no other questions for this witness, Judge.
I don't either. You are excused, Ms. Desai. Thank you. You're free to go.
Thank you. Bye-bye.
And then is that all of your case in chief witnesses, Ms. Locke?
It is, other than myself and attorney's fees, but I figured you would address that with both Mr. Case and I at the end.
I will if you have time. We'll see where we go with attorney's fees.
Thank you, Judge.
All right, Mr. Kazin, back to you. Where do you want to go next?
I have to complete my examination of Mr. Whitaker.
All right, let's get to it. Back on the stand, Mr. Whitaker, you are still under oath. And now we are moving to kid issues, I believe. You may proceed.
I know, Your Honor, and I'm just checking a couple of notes. I am going to move to kid issues, but very quickly I want to ask Mr. Whitaker about the valuation of the business that got sold, because there was some commentary about that from Mrs. Whitaker. Mr. Whitaker, would you tell me, please tell the court what was correct and what was incorrect about Ms. Whitaker's testimony on the final sale price of your business?
So first of all, prior to my arrest, I was an employee of Whitaker Private Wealth. Ms. Locke showed my W-2 as an employee of Whitaker Private Wealth. I also was a owner of Whitaker Private Wealth, and I received owner's compensation in addition to my employment income, which in 2023, which was the year that she showed, my business made over $700,000, while as an employee, I made somewhere around $300,000. On an annual basis, my business would make somewhere around $150,000, whereas as an employee, I made around $400,000. And a business valuation, had this situation not occurred, would have been based on the $150,000 of owner's equity that I would receive annually. At an aggressive valuation, that would have been $450,000. Well, that's out the window. That's a windfall for the community estate because we were able to sell the business. The valuation spreadsheet that Ms. Locke kindly shared showed a valuation between 2 million and 2.8 million on the upside. I actually was a purchaser of businesses and very involved in purchasing financial advice businesses. The 2.8 million would be if the owner of the business stayed on for the next 18 to 24 months to help with the transition of the clients. The $2 million valuation would be if there was just a cold transition to a new buyer. There was no case where I was going to be selling my business and staying on for 18 to 24 months with the transition. Furthermore, on that valuation spreadsheet, which I don't know if we're able to pull up that exhibit, I could point something out that I think is important for the court to know on this valuation.
On the valuation of the spreadsheet?
Well, the spreadsheet that Ms. Locke pulled up that showed $2 million to $2.8 million. I don't remember what exhibit that was.
Okay, I tell you what, I think I know which one it is, but what I prefer you do is just continue to testify while I find it.
Okay, I'll just explain real quick for the court. There's two important factors on the right side of that spreadsheet. One of them shows advisory revenues, and one of them shows brokerage commissions. The brokerage commissions was roughly $400,000, and those are one-time commissions. And when you're buying and selling a business, typically you only want to buy the revenue stream, which is up there on the top right, which is the $598,000, and the trailing commissions, which is the $3,000. So ultimately, what the purchaser of this business was purchasing was that $600,000 revenue stream. Well, we were extremely fortunate. We got a multiple on that revenue stream because of my relationship with the purchaser, because of a successor agreement we had with the purchaser prior to the situation of over 3 times that revenue stream. Well, this situation, I would have never dreamed of having to sell my business. I had a succession plan in place with this purchaser in the event that something were to happen to him or happen to me, and we were very fortunate. We sold it for $1,865,000.
In general, for those of us who are not as acquainted with the ins and the outs of business sales as you are, did you sell it at a loss, as she claims?
No, I think this was a tremendous windfall for the community estate.
By the way, she also indicated that the house sale was hurried and that she didn't get, or y'all didn't get, full value on the sale of the house. Is that correct?
I did hear that.
Well, did you get full market value for the sale of the house?
Yeah, upon separation, we talked that we were going to end up having to sell the house. We continued to postpone it as we were working through divorce proceedings, and ultimately the house was on the market for about 5 months, and the house next door to us was on the market for over 2 years, and we sold the house for somewhere in the range of $2 million, and we bought it for a little less than $1.5 million, and so that was some pretty substantial appreciation on the house over the course of 4 years.
Now, quickly to kids' issues. I want to share my screen with you. You and your family, before your incarceration, were, is it fair to say, fond of chronicling your life together in pictures?
Yes, sir.
So up on the screen, I've got just some family photos marked as R53. You've seen this exhibit before, have you not, sir?
Yes, sir.
Is it in fact a compilation of your family photos
Yes, sir.
for R53, Your Honor?
No objections.
R53 is admitted.
So, Mr. Whitaker, I'm going to ask you a series of questions while I've just got this up on the screen, and I'm going to slowly scroll through it so that we can all sort of just listen to your answers to my questions at the same time, you know, glancing at these and taking them for what they're worth. In your household, before the breakup, what were the various roles between you and Ms. Whitaker?
I would say that I was the primary caregiver. Lacey traveled a lot, and I took on the brunt of keeping the family moving forward on a daily basis. When the kids woke up in the morning, oftentimes prior to Weston going to kindergarten, her and I would get the kids ready. I would feed everybody breakfast. I would take the children to school. That's one of my favorite pictures right there, me and Weston. But I did daycare, drop-offs and pickups. One of my favorite times was picking the kids up from school every day. They all just lit up, and especially Desi, she would just scream and run and jump in my arms. And my other roles was I cooked dinner and managed dinner for the family nightly. I grocery shopped for the family every other Monday. I took the kids grocery shopping, and it was a fun excursion and allowed me more time with them. Lacey's roles, we kind of would both help out with bedtime. And that was one of my favorite times as well, was bedtime. She did the dishes because I was cooking. She managed the maid service. I managed all the contractors. With regard to the kids, I changed most of Weston's diapers. She took the brunt of changing. She changed a lot of Desi's diapers, and I would say with Julie, we probably split. And I was the fun dad. So I met them where they were. I always got home and played and made life extremely fun. We went to Disney World every year, and we went on great vacations. And Lacey was the more orderly and structured one. She wanted order and structure. She wanted dinner, everybody to sit in their spots, and the kids didn't want to sit in their spots. After they finished dinner, they wanted to jump over in Dad's lap because we'd make fun thing. We'd have fun times and laughs out of dinner, and they all wanted to feed me.
So what else about Miss Whitaker's side of the division of labor in the home?
She was pregnant 3 times. She breastfed our children for anywhere from 9 to I think 13 months with Desi. And as a result, the bulk of everything kind of fell on me. For Halloween one year, she bought me a costume that said Super Dad with 8 hands, because I was the one that was always just loading the car, loading the kids, getting everybody ready because she was getting ready. Also on the weekends, I would wake up with the kids at 6:30, and it gave me 3 hours of extra time with them because she would wake up around 9:30 on the weekends. And so I got extra playtime, extra cuddles. That was how I had to work it in with my stressful business life.
It looks from these pictures like you took a lot of family trips. Is that accurate, sir?
Yeah, we took a lot of trips to the beach. We rented an RV during COVID and went to the Grand Canyon. We did Disney World and Disneyland every year. The kids, I didn't get to experience much as a kid, and so I've always wanted them to be able to experience life in different cultures, and so that's what we did.
Okay. Let's talk about each child one by one. Tell us about Weston from birth to kind of now. Take just a moment or two to kind of explain what kind of kid Weston is.
Well, it's virtually impossible to do it in a moment or two, but I know we're on a time constraint here. But Weston and I, from the moment of that picture you saw earlier, we've had a bond that's just been supernatural. You know, they say not to be best friends with your kid, but Weston and I are best buds, best pals. He's he's just the most incredible. He's super smart, super athletic, extremely competitive. Everything him and I did was a competition, whether it was racing up the stairs, who could pick up the toys the fastest, or who could give mom the most kisses. And every free moment I got, he'd want to play baseball or go to the golf course or play Pokemon and just have fun. And the first time I talked to him once I was incarcerated, talk about being a best friend. He told me, Dad, this is all part of God's plan.
I'm gonna object to hearsay.
Yeah.
Okay,
Um,
I can move
I
on.
mean, okay.
And
So what are the things that you feel like are important about Weston as a young human being who isn't in control of any of this, that whatever's going to happen here is going to happen sort of to them rather than by their making? So tell us about Weston's, your understanding of the kind of child he is and your concerns about whether you're going to get to remain a constant in his life.
Weston, we're fortunate he's got a great group of friends that they play sports year round. He's just got a great little support network in the friends and in their parents. He's all in on playing sports, and you know, my role in his life was just somebody to give him attention, show him he's loved, take him out and spend time with him. And once I was incarcerated, my friend Ryan that was on earlier, he was, you know, kind of stepped in and spent a lot of time with Ryan, but through circumstances which I don't think we need to bring up to the court today, Ryan has been alienated from the kids. And I just don't know what father figures or men are in his life. And every time we talk, he asks, Dad, when do I get to talk to you? Yeah, I guess hearsay. But I'm a force of love for him, a force of encouragement. We did math for 30 minutes on our video call the other day. And I want to do everything I can do to show up for him, whether it's showing up on video or being back and reuniting with him and being there for him.
Yeah. So just before we move off of Weston, I'm gonna share with the court a video. You provided me a few short videos of the kids for use in evidence, and when you did, you sent them to me with date marks and the profile names. Do you recall that, sir?
Yes, sir.
There's one here that's dated, it looks like it's January of 2018. Weston would have been a little over a year old. Do you recall?
Yes, sir. He's actually coming up on 2 there.
Okay. This video, are you familiar with the video that I'm talking about?
I'd have to see it. I think it.
It's very short.
Yeah.
If you gave me a video and it's got this in the profile name, was it taken at the time? And it's in the profile name?
I have to see the video. I'm sorry, David.
Okay.
Yes, I would believe so.
In any of the videos that you gave me, did you alter them, change them, edit them, take anything out, anything like that?
No, sir.
I'm going to offer respondents 59.
No objections.
I think she said no objections. 59 is admitted.
That's correct, Judge. Sorry.
It was just cut off a little.
Can the court see this video that's playing?
No, I cannot.
Okay.
How long is it? I can try and play it on mine. Just watch it real fast.
It's quite short, Your Honor.
Okay, let me just see. Since I admitted it, and I'll just try and watch it real fast. I'll let you know. Hold on. I watched it.
Could you, Your Honor, if you don't mind me asking, could you hear it as well?
I couldn't, but it looked like a cute baby saying daddy.
Kind of important to hear that one, but that's all right. I can move on.
Well, I mean, I don't know. I can't make it play audio if it didn't have audio. I tried. So if you want to try to get me audio of that, you can, but I can't make it do something that I didn't have. Was he saying something other than audio? I mean, other than daddy?
Yeah, it was just kind of a demonstration of affection between father and son.
Sure, I'm sure it was. It looked like he was a very happy baby.
Okay. Mr. Whitaker, and I'm going to go ahead and the same is true for all three of these next ones, 60, 61, and 62.
Yeah, if you can try. I don't know. I see it now. I now actually see it on screen, but it's showing up with the, the warning cone. And so I don't know what that means.
Well, I'd like to offer R60, 61, and 62.
I don't have any objections.
And 63. Well, and 63, although I don't know that I'm going to play 63. I'm going to reserve that.
I don't.
They're
have
all
any
admitted.
objections.
They're all admitted.
I will try to play this, and if it plays, then great. If it doesn't, then I'll ask the court to do it. Can the court see the video?
No, can you see it?
Yes. Just a second.
I mean, I can see a screen, a frozen screen with Ariel. That's what I can see, but I
Okay.
don't see anything playing.
Then I'm going to do this again.
Now it's sort of movement. I see movement. That seems possible. I can't hear anything, but I can see it.
Well, they're singing happy birthday, and it's a shame because it's really nice. And that's Desi.
Job. Thank you for asking you.
Mhm.
You smell your sparklers.
I could hear it that time.
I'm about to try R62. All right, Your Honor, I'm going to move on because I can't seem to get this to work. So, Mr. Whitaker, if you would mind, tell the court a little bit about Desi, and kind of like you did with your son, but just kind of from birth up to now.
All right. Desi stole my heart from the day she was born. She is the ultimate girly girl. She loves princesses, rainbows, unicorns, and makeup. As you saw from that video, my favorite hairstyle for her was two up ponytails. And when I went out in public with her, every time we went to the grocery store or anywhere else, it was like being with a celebrity because everybody would stop you. And being the second child, she didn't necessarily need attention, but when she did want it, she knew how to go get it. If you were cuddling with somebody and she needed attention, she would just bulldoze her way right into the middle. at dinner time, she sat next to Lacey in our nook, and she wanted to spend time with dad, and she would have to barrel through Weston against Lacey's objections and, jump into dad's lap. Desi and I, we have a lot of fun drawing together, painting together. She's our little artistic one. She's always singing, dancing. Speaking of dancing, when she was barely walking during the pandemic, I caught her dancing against the baby gate, and I dove on the floor and started recording her. And this is like March of 2020 when the pandemic started. And that video, I ended up posting it on social media, and it went viral. She had over 75,000 views. We spent a lot of our video calls drawing. She loves teaching me how to draw the stuff she's learning in kindergarten. We spend time playing tic-tac-toe, doing math. And one of my favorite trips with Desi, I took Desi and Julie, just the three of us, on a cruise, a Disney cruise. And it was 4 days, 3 nights. And the girls dressed up in their princess dresses every day. We got professional photos done on every corner of the boat. She got a complete makeover from her fairy godmother at the Bippity Boppity Boutique. And once again, it was like I was with 2 celebrities everywhere we went. And
let me let you pause right there, because I have another photo that I want to use while I'm asking you a few questions. First of all, what is this we've got up on the screen, sir, if you know?
The kids made this for me with I believe the help of Lacey for my birthday in 2023 after we were separated.
You gave this document to me, and have you altered it in any form since giving it, since it was received by you from the children?
No, sir.
Is it a true and accurate representation of what you received from the children?
Yes, sir.
Offer R58.
No objections.
58 is admitted.
Okay, so you were talking about Desi, and I interrupted you. How have we saw some of the supervised visitation notes about the time that you spent with Desi. With regard to Desi specifically, how would you say that went?
We had an incredible time. She always sprinted ahead of everybody to get the first hug. She wanted to be the last to leave. We just, soaked up as much time as we could during our time together. And I was fortunate enough to get some one-on-one visits with her, and we painted each other's faces. She painted my nail. We painted, we drew, we colored, we played cards. There's another Disney card game that she's all into now called Lorcana. And we just had a lot of fun.
All right. So peering into the future, if you can, about the young child you know as Desi, knowing her as you do as her father, do you think about your current circumstance and what do you think is important about her as the child that you know staying connected to you?
Yeah, it's obviously a challenging circumstance. She's always excited to talk to me. I believe having a force of love and support in her life is something that's going to benefit her long term. These circumstances are really difficult, not only on Lacey, me, but they're also difficult on the kids. And I want to be able to show up and support them and help educate them, encourage them, and as much as I can through this process while I'm away. And, I'm excited about, being able to get reunited with them in the not so distant future.
Okay. All right. Let's move on to Julie. Now, you were asked questions by Ms. Locke about, what it is Julie knows and what it is she's aware of at her young age. How do you think the supervised visits have gone with her?
Julie and I, we've had a great time at the supervised visits. The best one I would say was when I took her and Desi to the princess spa, and for a 3-year-old, she soaked it up. It was like she was a natural at this princess spa, like she belonged there. They got cucumbers on their eyes and got many facials. They got pedicures and manicures. They got makeup and face jewels. And then there was a runway where the fairies introduced them, and she just kept coming down the runway over and over, just excited and with the biggest smile on her face. And she always wanted to be in my arms. I carried her everywhere we went, which meant I also got to carry Desi as well, because if one of them was in my arms, the other one wanted to be there. And we just had a lot of fun.
So I'll show you real quickly, Respondents Exhibit 56. What are we looking at here with Respondents 56?
This is something Weston drew at school. I believe he was in first grade.
Okay. On this next page, it says, "I am thankful" by Weston. And then he says, "I'm thankful for," well, before I get too far into this, for Respondents 56.
I'm assuming the child's statements are not being admitted for purposes of the truth of the matter asserted, because if that's the case, then I object. If not, then it's fine.
I'm going to assume that too. And so this is R56 and it is admitted.
R56. So the statement on the page says, "I'm thankful for my God. I'm thankful for Pack Wars." So what is Pack Wars?
So when we started playing Pokemon after Weston's 6th birthday, because he received Pokemon as gifts, I created a game called Pack Wars, where instead of just ripping through the packs, we were able to turn it into a game of strategy and math. And you open the packs, and then your 2 packs go quote unquote war against each other. And he came home from school with, as he was learning handwriting, daily, weekly, with documents like this. And that's one of the reasons why we got so into Pokemon, was because he loved Pack Wars, and he came home with it every week. It was so cool.
So Pack Wars was a game you created. Do I have that correct?
It's a game created that we still play.
But the nature of the game, maybe unbeknownst to your son, I mean, you had an educational purpose for it, right?
Yeah, and he's a math wizard now.
I recall there was something in the supervised visits about a game you created for one of the children so that they could learn better math skills. Do you recall that?
Yes, that was actually with regard to Desi.
Okay. So are there other games besides Pack Wars or the one you did for Desi that the court should be informed of that you've created for the children that were fun but educational?
I mean, we played a lot of board games, and Weston, by age 4, he was the banker in Monopoly, and that's how he started learning math at an early age. And we're just always playing games and coming up with fun things to do together.
Showing you some photos that are marked as R64. Do you know when these photos were taken?
Yes.
When were they taken?
That was Weston's birthday, May 14th of this year.
Offer R64, Your Honor.
No objections.
R64 is admitted.
There's a photo here of, is that you and Desi?
Yes, sir.
Is it a true and accurate representation of you and Desi?
Yes, sir.
Offer respondent 65.
No objections.
65 is admitted.
When was this, Mr. Whitaker?
This was May 15th, 2023.
Where was it?
This was at Mr. Wuerch's house.
So if you wouldn't mind, tell the court what you're aware of is available, at least where you are now and where you may or may not be, if you are allowed to have visits with your children while incarcerated. Get the court familiar with you know, the environment, if you wouldn't mind.
Yes, sir. So currently I'm in a holding period, waiting trial. During this holding period, I have access to video calls, but I would say in-person visits, this wouldn't be the time where it'd be appropriate. My access to video calls at this point is from 6:30 in the morning until 9 o'clock at night. And I can do them anytime throughout the day. What I understand in the event of incarceration in federal custody is they have visitation on the weekends from 8:30 in the morning until 3 o'clock in the afternoon. It's not in a glass environment. It's in a supervised in-person environment where you can play games and draw and have a lot of time together. From what I understand, if I am at the end of this detained in federal custody, is I could potentially be detained as close as Bastrop, Texas, and I could also be detained here in North Carolina. And video visit access, Ms. Locke touched on this a little bit yesterday, but there is a limited number of hours or I guess minutes or hours per month that you're allotted. And I feel very comfortable that if we are awarded an hour a week with each child or some version of that, that I'd have adequate time to spend with them either via video or via phone calls.
Do you want your children to be able to have normal children extracurricular lives, being on teams and team sports and team events? And how does that square with a schedule for talking to you? And also, if you wouldn't mind telling us, how do you feel about how to balance that and what's more important?
I absolutely love that they're involved in extracurricular activities. I believe video calls, if an extracurricular activity comes up or a birthday party or something like that, it should be pretty simple to reschedule a video call. It's proven to be extremely difficult over the last year to reschedule those video calls, which I can elaborate if I need to.
Well, let me pause right there and ask you a couple of questions about that. Have there been times when it's perfectly good communication and then other times when it's not? Or has it been always good or always bad? What would you say?
It's mixed.
Okay. So you heard Ms. Whitaker talk about concerns about restrictions that you want placed on the video calls. How do you respond to that?
What I asked the court and what we petitioned the court is just to provide some reasonable guidelines and etiquette for conducting video calls with children. These calls are about them. It would be easy for me to spend my time in a little hole, and the hardest days are when I talk to them. But these calls are for them and about them. And I didn't feel, and in discussion with my counsel, didn't feel that conducting video calls in a loud restaurant where they're trying to, eat and play with other folks is appropriate. There was about a 5-week period where whoever was on the video was getting served dinner at that time. And so it wasn't like they were all sitting down to dinner at the same time and eating at the same time. I had 10 minutes with each of them, and whoever was on video, they were eating. So they were focused on eating. They couldn't talk. I don't think it's an environment where you need to turn off all the TVs or not give them snacks or anything like that. I'm just asking for just some reasonable etiquette to just make this time meaningful and valuable to them. I lost my dad when he was 19, when I was 19, and it sucks. And these kids have nothing to do with the situation between Lacey and I or the allegations against me in North Carolina. And they have a dad. They have friends that have recently lost dads, that their kids can no longer talk to their dad again. And someday they're going to be thankful that they were still able to communicate with their dad through this challenging time. And I believe are going to be excited to reunite on the other side.
What would you, well, do you understand Lacey Whitaker's concern as she voiced it for the welfare of the children? Given your circumstance and what they're going to understand as they grow up and what they're going to feel about that. Do you understand anything that she had to say?
What I heard her say was that she thinks jails are scary places. I thought that too until I was incarcerated. I have a much different opinion on that now, and I've done a tremendous amount of research on the impact of children being alienated from a...
Judge, I'm going to object now. This is non-responsive and he's not an expert in this area.
He's not offering it as expert testimony, Your Honor. He's just
Overruled. He can answer.
I've done a tremendous amount of research on how to help children through an incarcerated parent situation. And children, they want to know what's going on. They want to know that their parent is okay. And by being able to come to the facility and see that it's safe, I feel like that reduces, from my research, a lot of anxiety for the children. It also helps continue the relationship so that when there is a reunion, when we are reunited, that we'll be able to move forward and put the past behind us.
Are you concerned at all that at any point in time the children will feel like you don't want to be in contact with them?
I'm unable to control the communication and the narrative that's shared with the children. And I would ask, that when the time comes and when we need to share what the past looked like and what happened during this time, that I'm part of the conversation. And I look forward to sharing with them the complete honesty. I wish I could share with the court today. But we're not in a position to do that yet. And I don't want the children to think that I wasn't fighting for time with them, as unfortunately has come up during our video visits.
During some of the time that I've got left, I just want to ask you real quick, just because of your expertise. You heard Ms. Desai talk about some criticisms of why, how you estimated the performance of your investment. She didn't really argue about the amounts contributed really, or the math. What she talked about was the fluctuation and not knowing which investments would have performed in which ways. How do you respond given what you heard, sir?
Yeah, just to discuss it quickly. What I heard her say is she didn't have all the information. It wasn't provided to her by opposing counsel. We have all the information of all the statements. From what I understand, they were provided for the LPL IRA. Opposing counsel also subpoenaed LPL, and I don't know to what degree why they didn't provide those to Ms. Desai. All of the data was there and available. She said that she didn't think it was reasonable to use the S&P 500 as a investment in the tracing. What she didn't mention is that 401k plans, and I don't know if the court is aware of this, they have very limited investment options. The reason I was very successful in my career was we would roll 401k plans over into an IRA because of all of the investment options available. Inside of my 401k plan, there were 6 investment options and there were target funds. I invested in target funds, which actually would have had a much lower return than the S&P 500 over that 18-month period. And I used the most aggressive investment, the best performing investment over that period for the community property portion, which showed returns of 20 to 35% over a 1 to 18-month period, which nobody's getting that. And that's why I felt like, we used a very conservative assumption in that situation.
Well, I apologize for bouncing around, but there's a bunch of sort of cleanup questions that I have to make sure that we've tried to address. One of the complaints I heard during Ms. Whitaker's case in chief was regarding the number of motions to compel that I personally filed. On the date that I filed any motion, did we have all the documents that were requested in the motion?
No.
Those would come after the motion and usually right before the hearing date?
Yes, sir.
Judge, I'm going to object to the mischaracterization because they were supplementation issues, not deficiency issues.
Well, the problem was testifying. So
Fine.
it doesn't even need to just, honestly, he just was testifying. So, and leading and all of the things. So there was a lot of problems with that question. I know y'all have disagreements about what happened and you can deal with it in legal argument. But if you're going to ask your client questions, Mr. Kazin, watch the leading and we'll just go from there.
So I was very careful, Mr. Whitaker, to ask you as we were going through the community property spreadsheets, if there's, what have I missed that you think is important? And sometimes you would direct me to something that I hadn't considered in my questioning. So I'm going to do the same thing with regard to your kiddos. Is there anything that I have failed to give you the opportunity to mention that you would like to say to this court you think is important to know about how it renders judgment on final conservatorship issues as it relates to child support or healthcare or possession and access, whether it's video or weekend or whatever? Is there anything that I've failed to give you the opportunity to say?
Yeah, there are two primary things I'll point out. The first one is in our petition, we requested to be joint managing conservator. While the circumstances right now are difficult and challenging, I've always been heavily involved in the children's lives. I've always been involved in their decision making. And I believe that on the other side of this divorce, Lacey and I, we've always been able to make decisions that we felt were in the children's best interest. And I believe that together we still would be able to do that. And on the day I walk out of out of these doors, you know, I want to be part of their lives and am, you know, would really enjoy the opportunity to continue helping make those decisions. The second thing, with regard to the children is just the video access, the makeups, it turned into just a really difficult experience for them, not knowing when they're going to get to talk to their dad again. You know, even just these past 2 months, they've got to talk to me, I think 4 times, and I've been more available during incarceration during these past 2 to 3 months than ever before. However, Lacey just doesn't answer the call. And we called on Thursday, which is, you know, in our temporary order. She didn't answer. We called on Sunday. She didn't answer. She just doesn't, she doesn't answer the calls, doesn't offer makeups. There's, you know, throughout this process, we've requested makeup calls, and talk about attorney's fees. I mean, you should be able to reasonably decide on a makeup call. I've spent thousands of dollars asking my attorneys to talk to her attorneys because we were unable to decide on, you know, she's neglecting the makeup for the children.
Your Honor, I've got on the screen a document. I didn't think to add it, put an exhibit label on it because I thought it had been signed with the court. Ms. Locke and Ms. Dyerly, who represented Mr. Whitaker ahead of me, both signed it. I've seen where it's been sent into the court, but for whatever reason, even though I've seen a couple of messages to Judge Arth, I believe, it's not been signed, but this is supposed to be the order of the court. Perhaps you see an agreed further temporary order in the file. If you do, I'm going to ask you to take judicial notice of it.
You mean a signed, agreed, further temporary
Yes,
order in the
it's
file?
possible it got signed and I didn't. It got by me and I didn't see it.
I don't know what, I mean, it obviously wasn't me either. Ms. Locke, do you know?
I don't, Judge.
So
I mean, I know we had an agreement because there was a Rule 11 agreement regarding this. I know it was submitted to the court. I will have to look in the file real fast to see if we actually have a signed copy. I can have Mr. Diaz look right now and see if we can find it.
and Your Honor, I just asked for permission to examine my client about the terms and conditions. I don't know that I need it to be evidence in order to elicit his testimony, but I do need it as an illustration tool. And as I said, I'll say to the court as an officer of the court, this is a true and correct copy of the one that was signed by both counsel.
I think we have the filed copy, Judge.
I would love. Do you have a file mark date, Ms. Locke?
It was filed on 11/27. So last week.
Okay.
Mr. Diaz will email it to you, Mr. Kazin.
And I can use that one more specifically, but I have every confidence that the text is the same. Can I proceed, Your Honor?
You may. I'll just take judicial notice of the file of the temporary orders.
Okay.
Thank you, Judge.
So this is supposed to be the temporary order of the court, Mr. Whitaker, and I'll show you that right here where I'm writing it. It says our family wizard, which is not an available tool right now because of the specific place that you are. But that aside, do you have video contact with the children in Ms. Whitaker's home?
Yes, it's been very limited.
But you have a method that's called PayTel, is that correct?
I have a method, absolutely.
Okay. And so, and you and Ms. Whitaker have used that method to speak with the kids before already?
Yes, sir.
And again, this language is used here, it says our family wizard, but that's not available. Nonetheless, there are some specific times that are outlined. It says Sundays each week between 6:30 and 8:30 p.m. 30 minutes each child. Did you try to make a call this past Sunday?
Yes, sir.
Were you successful?
No, sir.
It also says on Thursdays for 30 minutes. Did you try on Thursday?
Yes, sir.
Were you successful?
No, sir.
Are you asking the court to place specific parameters and to the extent necessary to fix this language about our family wizard, change it to the Paytel device that is now appropriate, or whatever video method is amenable to your place of incarceration? Is that kind of what you need in order to get these calls at least court ordered?
David, what I would ask the court is, we don't know what the next month is going to look like. We don't know what the next year is going to look like. We're asking the court for an hour a week with the kids. We were asking for 40 minutes a week previously. And there was many times where we weren't even getting the 40 minutes a week for the children to be able to spend time with their father. What I would hope through this process is that we have two folks that the court can agree, can make some kind of agreement or some kind of request that these are important for the children, that they need to happen weekly, whether it happens Sunday at 6:30 or Thursday at 6:30. I think it's to support the children. This worked. What we found that worked was, Sundays at 6:30 and Thursdays at 7 o'clock. But there's times when there's other things going on. I imagine Lacey was probably driving home from her parents' house, and traffic on Thanksgiving on Sundays is terrible. And so with that, I would say, hey, there's a little bit of grace. If you're not available on Sunday, let's shoot for another day. But our communication has been so restricted that the only way I can communicate with her is to pay you your hourly fee to communicate with Miss Locke. And we just need a form of communication that's in the best interest of the children, that we can reschedule these and commit to them for the children's sake. And yes, the system right now is Paytel. Like next month, it could be Telpay. Next year, it could be Verizon.
The order, whatever it says, should describe whatever's available generally, because it's always going to be a different provider. Is that fair, sir?
Yeah, and then on the other side of this, I imagine we would go back and petition the court to, make adjustments.
Okay. Thank you. One last chance, sir. Is there anything else that I left out or didn't give you the opportunity to say?
Regarding my children or in total?
Well, if I'm about to say past the witness, so if there's anything that occurs to you, tell me what it is.
We didn't go through any personal property in our examination. I don't know if that matters.
Well, there's an exhibit, and I may need some direction from the court, Your Honor, because counsel and I did speak during lunch. I'm not sure how much is agreed. I think we're kind of on the same wavelength, and if you're figuring on having us back, I would simply ask that you continue the proceeding to whatever date that is, so that we can get the estate organized. But if you're really going to have a hard stop today and render judgment, then I'm going to offer each of the exhibits that is named on the far right corner of our proposed disposition of issues, and I can give you a list of those.
I mean, so you're done with your client? You're
I'm about
done
to pass.
asking him questions?
That's correct, but I'm looking
Okay, that's
for-
great. Then Ms. Locke has about 3 or 4 more minutes. I think we can talk about logistics. Ms. Locke has 3 or 4 minutes left of her time. She may not have any questions for him, but I think I should, if you're passing, she has that.
I'm going to pass. I just don't want to say arrest if I haven't.
Correct. No, I get it. And we'll talk about that in a minute, but let me first see if she has any cross-examination questions with the 3 to 4 minutes that she might have left on her time.
Judge, the only thing I want to do is introduce P78, and I'll share my screen. And it is and just so the record's clear, I have no other questions for Mr. Whitaker.
All right.
But I
So,
have
no questions for Mr. Whitaker. Got it.
no. I only have 4 minutes left. It would take longer than that. But this is P78, and this is my client's. It's the Roth IRA bank statements that from 2017 to present were in. Anyways, these are the true and correct copies. So I moved to introduce P78.
No objection to P78, Your Honor.
All right. P78 is admitted. Okay. So obviously, I think this case was a little misrepresented to me back in December or 3 weeks ago when it was represented that there wasn't a lot of property issues. I think how y'all perceived it and how I perceive it are vastly different. And so I need to consider what all it is that I need from you. But the first thing I think I need is some sort of joint, maybe just, can you at least agree on what the questions are? Like, I know there is a waste issue with regard to the babysitter and the attorney's fees, or a reconstitution issue, whatever you're calling it, Ms. Locke. But I think there's an outstanding question about that. There's an outstanding question about Mr. Whitaker's separate property as it relates to 3 or 4 different accounts. I kind of got a little lost in the weeds about that. I got to be honest, because y'all just kept throwing accounts at me with numbers, and that was a little hard to follow along with. But I know that there is that issue too. And then it comes down to a question of fault. And you're asking for fault on basis of cruelty, I think.
Correct.
And whether or not, if I grant that, whether or not you would get a disproportionate award, because even in Mr. Kazen's presentation, granted, he doesn't think you get the reconstitution. He doesn't think he thinks there's some separate property. But I think once he gets to his numbers, he's even saying it's a 55-45. Almost felt like to Miss Whitaker's favor. And so granted, the devil's in the details there, but I understand that. I think those are the big issues with property, but I think that just kept getting very confusing. I maybe wouldn't have done this by Zoom had I known about the significant property issues, because those actually do work a lot better in person. But it was represented that there was maybe one property issue, and there turned out to be probably like 8, 9, 10 to the extent of hundreds of thousands of dollars. And so I just think that got a little more difficult to do by Zoom. But I'm doing my best with it. I think I caught up a little. Because of that, I'm not going to ask you to rest, because maybe we have to put in some more evidence based on questions I might have. But I am going to ask you to do some sort of, if you can, joint presentation to the court that is at least almost as if, what are the major questions that the court has to answer to get you to the property division you need. I understand the conservatorship issues. That really, I mean, there's obviously a big disagreement, but I think I don't need it necessarily broken down for the court. I think the one thing that neither of you presented, just so you know, that I think is on the table for the court, though I understand why neither side is asking for it strategically, is some sort of divorce decree that allows, like many sorts of divorce decrees, that allows for contingencies based on what happens to Mr. Whitaker in his criminal trial. Thus, there's a time frame right now based on him awaiting trial. There's a potential time frame based on dismissal or acquittal, and there's a potential time frame based on a potential contingency based on conviction. And I think even within that, there are some other options, I think. But I think those are the three big ones, right? We have now, we have acquittal, dismissal, and we have conviction. And we can, within the context of best interest and just and right, basically make rulings based on that. I try a bunch of cases. To your point, Mr. Kazin, basically every case I've ever tried in family court has things we don't know. I've never gotten one where I've gotten all the information I needed and everything was everything I could possibly need to make a ruling. I do agree there's a pretty big thing we don't know about this case, but I try plenty of cases where that's the situation all the time. So I'm just going to take it all in. Also, y'all have given me a lot of significant exhibits, I think, to look at too, that I haven't had time during the presentation of evidence to really go back through them. So I think I just need time to do all of that. What we'll probably do is reset this for an in-person setting after y'all have had time to kind of do that joint presentation, some sort of joint document to me, almost like an agreed, denied, or rule for respondent, rule for petitioner type of, almost like a checklist kind of. And I recognize you may not be able to do it completely because some of it's going to be a decision tree type of thing. But I think there are some things, like just especially with regard to your presentation, Ms. Locke. Does the court find there is waste? If so,
Correct.
how much? Does the court, that sort of type of thing. And then I think you have the burden, Mr. Kazin, with regard to some of this separate property. Does the court find this to be separate property or not? And, if yes, how much? Kind of that sort of thing. I think there are ways to do this that could be helpful, that get us there through a little more efficiently. That would be better to do at a later date. Then you both, I think Ms. Locke has attorney's fees that she's seeking. I don't know, Mr. Kazin, do you have attorney's fees that you're seeking?
I'm not, but I would.
No.
I'm not
Well, if you haven't
requesting
applied for
them.
it, then you're not seeking it. So.
Well, no, but I would have wanted to testify on the topic, not for the purpose of requesting them.
But for the purpose of rebutting hers.
Yeah, and to talk about the reasonableness on each side, et cetera.
Right. Well, maybe we'll make her do an affidavit, and then when we convene with her fees, and then when we convene, if you have any questions about that affidavit, you'll be able to do that at that time.
Okay.
That's another reason to not close the record.
And that's fine with me, Judge. Can we go ahead and get some kind of date on the court
let's do
so
it.
that
I mean,
we need an end date? My client's really ready to be divorced.
No, I got you. And I could even potentially render. My problem with rendering is I think I know what I'm going to do on fault, but I need to check one thing. I really just need to check the law as to a couple of different points before I make my ruling on fault or no fault. And so, or fault or
Irreconcilable differences.
Yes, irreconcilable differences. So I don't want to belabor this forever, but we could potentially do it the week of January 6th. I'm the duty court that week.
The only problem I have is I have a Bell County trial that may settle in the next couple days, but we'll also have two trial settings. One's the 16th of December, and then if that one doesn't go, then we're going the 6th. So I would say I could set it, but I just don't know what's going to happen with that Bell County jury trial.
Well, it's not a great week for me either. I was giving that to you because I was trying to be mindful of your concern about your client, but it's not a great week for me, so I'm okay to not set it that week. The next week I would have is the week of January 20th. So I'd be able to do it the 22nd, the 23rd, or the 24th of January.
I can do the 23rd or 24th.
I'm good either of those days, Your Honor.
Then let's set this. I've lost my JEA. She has gone, she had to leave early. But let's set this for closing argument and closing argument and follow-up. We'll leave it open, right? Like we're gonna leave the case open because I don't want to quite close it yet in case we've all forgotten something.
Yes, Your Honor.
An in-person setting at 9 a.m. on January 24th. I don't know if Mr. Whitaker will be able to be here or not. It sounds like the jail has worked with him, though behind the scenes I learned that has been a little bit more difficult than perhaps I've been led to believe. But currently we will finish trial and close evidence. We will continue this matter until January 24th at 9 a.m. But we will do it in person. I need you and Mr. Kazin in person.
Yes, Your
I
Honor.
don't care if anybody else is in person because the only evidence, in my opinion, that's left to do is your attorney's fees and closing argument. And to have some sort of understanding in the room together where maybe we can walk through these questions one by one in a little bit better way than we've been able to do it by Zoom. But that's my intention. Obviously, it's open courts. Your clients can be there, but I don't need them there for my purposes.
Thank you, Your Honor.
Any questions?
So the record's clear, evidence is not closed officially
not.
until we come back in January.
Yes.
Okay.
That's just to leave ourselves a little bit of an out if we have forgotten to do something. Mr. Whitaker is raising his hand. I'm okay.
You asked
That's
if
a
there's,
you.
you asked if
Go
there's
ahead.
any questions. Can I ask? Between now and then,
The temporary orders are still in effect. But they are what they are. I don't know what the jail will do. My understanding is there's a jail problem, but I'll let y'all figure it out. But I'm not going to do anything on that until I get like a motion that would enforce the temporary orders. Thank you.
Are we excused, Judge, or we're done?
Yes, you're excused.
Okay.